You mind just giving us a rundown as to what happened?
Yeah, so Hobbs bench trial, big shocker. The scene from yesterday, he wasn't being charged with any of these murders because he was shot down for whatever reason prior to the shooting starting. I guess the officer involved shooting starting.
Sorry,
Bench
can you
trial,
repeat that? He was already shot down.
yeah, he was
prior.
shot down and then the cop shot started. So he didn't
Okay,
he got shot down for just like criminal threats, issuing, let's say, I'm gonna fucking kill all of you, whatever was warned to stop, yada yada yada, besides the point. The bench trial lasted probably 4 hours. Three, 4 hours.
5 hours. It was five
really
fucking
long.
hours.
It was really long. And at some point, fucking during the bench trial, I've either my mind spaced out or I was tired, whatever. I made the mistake of adding my statement into it, which had no relevance to Jay Hobbs at all. My statement did not mention him, whatever. But they used the fact that I edited the report, and they stated that there were like 50 or so edits to the report from the start of the bench trial to invalidate it and dismiss the case with prejudice entirely. And they said that the integrity of the report's lost. I pointed out that, well, apparently Josh Cade, because like Cade and Quango were there. I wasn't there at the time of like that discussion with the judges. Apparently Cade mentioned that, can they not just look at a past history of the report and reference and go based off that? Because it's all accessible to them. And they said no. They said they're not going to use the past history. They're not going to look at that. And basically they just weren't willing to entertain it. It just seemed like a big waste of 5 hours to me for that to be the end result. I tried to explain that I understand 100%, you know, editing parts of the report that are being used and in general is like, it's something that can be done should it, you know, jeopardize stuff having to do with the actual what's being discussed. I wasn't like blind to that. I wasn't trying to say like, you know, that isn't a thing.
5 fucking hours to be thrown away for that.
I was trying to like bring light to the fact that we are operating with what we have MDT wise. We have no way of locking reports. We have no way of ensuring that nobody will touch the report. People go home and finish their paperwork. People are going on with their patrol and finish their paperwork. Some people don't even read, like, some people open the report and don't even read what's at the top and just scroll down and they're on autopilot, right? At the end of the day. There's no way of us stopping people doing that.
I mean, within the first 48 hours is generally no reason to stop someone from doing it. You're doing your job if you're
you're basically following SOPs at that point.
Yeah, as operating normal, that's just what people do normally. That's that in their normal day to day.
Yeah.
And I was trying to say, like, you know, this just seems like a crazy thing to throw out the entire bench trial for. If especially that
it's a waste of everyone's time.
Especially that they have the edit history available to them to see what it was at whatever time they would want, and they could just reference that and use that. This seems like they just didn't. The point I made to Falconer is that it seems like PD is held so much often, like time and time again, to such a high standard in being meticulous and being hyper specific and holding everything in the pockets for photos and showing this and showing that, but absolute like very minimal effort was put forth by the judges there in order to like come to a means that wasn't throwing out the court case. Like they did not even care to like look at edit history and cross-reference what was changed, because when I cross-reference what was changed, the only difference was me adding my statement, which was me showing up after the shootout started and getting shot down.
Everyone is bringing up work or home or ICU. Yeah.
Employees, so it didn't even affect.
Okay.
I do have a counterpoint. Generally in the past, we've always had to, before we went to bench trial, it was on the officers that were taking it to bench trial to make sure the report is done and finished. So that way it's not being edited. I don't think, well, I think this is like a fucking petty reason to throw something out, especially when I don't think your testimony was submitted. Obviously all the reports are submitted as evidence because it's the report, but
it wasn't referenced at all, I guess.
Yeah, I mean, it's something they do take into account when going over situations. It's unfortunate it happened, but honestly, I think the solution is, if we're going into these huge situations, it either needs to be posted on the docket if somebody wants to contest it, because like, I mean, it was a big set. How many officers got shot down? It was over
19.
Yeah, I was gonna say, okay, so 19 officers got shot down. To get statements from everyone in that situation, collect evidence and all of that, and then somebody to ask for a bench trial and us grant them the bench trial immediately is kind of our fault in that situation. I think it's just ultimately coming down to
The scale of the scene.
We have to request it. We just have to request that it gets.
I think the vast
pushed to the
majority of
docket.
officers don't know that you can, figuratively refuse it because you're not ready. Like I think a lot of PD is under the impression that when somebody asks a bench trial, you have to put the request in.
well, you do,
regardless of if.
but we have to. The thing is it's on the judge to turn it down. So the cop then has to either call the judge and be like, look, they're requesting a bench trial. I still have to do this, but in the again in the past, it's a bench trial is like they sit in a cell until everything is collected and all evidence and basically everything submitted on something.
And I feel like, sorry, go ahead, keep going.
No, I was just gonna say something like of this scale to go straight to bench immediately after is kind of. I mean, listen. The city moves fucking fast ultimately, and it's one of those things where I think the DOJ has unrealistic expectations, but moving forward, it falls on the PD to be like, if you want a bench trial, you're gonna have to wait until every single person has their statement in or something.
My issue with bench trials,
that's just not realistic.
My issue with bench trials is I feel like bench trials are held 100% to the same standard as a full docket posting. When I feel like a bench trial, it should be a little less. I don't know the legal.
Yeah, with a case, you at least have time to prepare and get everything together, and that's a mad scramble of trying to articulate everything.
I really like bench trials, and I don't want everything
like
to
making
go on
a
the
shot
docket.
call on a scene.
Right. I don't think it's realistic to even.
Bench trials should be an hour long.
When
Yeah, you're not fucking wrong.
Showing up on the scene and
and what,
be taking
3
evidence
or
and
4
half
of them can be in fucking ICU
or asleep, and they're on the floor for 2 hours. Sometimes they get up and they just rest it off, and there's a lot of aspects to it. I think we just need to. I don't know if we want to have a standard.
This is going to fuck criminals so hard.
At some point,
not necessarily.
We leave it up to the officer who's pressing it. But maybe we need to remind them that we have the ability to request for it to go to the docket. I think we have to request a bench trial, but in that request, we also state that this is a large scale scene and requesting that this the defendant appeals it on the docket.
Yeah, I think
I'm talking like a minimum like 6 or 8.
It's just running arrests and doing police work is fuck criminals more.
I do like bench trials. I do like bench trials. I don't, but the point I made to Falcon yesterday is that no officer, like any of the officers that were there, left that courtroom not looking forward to the next bench trial. Nobody's looking forward to going back to court after that, and that should never be anybody's mood leaving the courtroom, right? And it's kind of it's like a double-edged sword, because you're saying like, right, we're not prepared enough for what they want from bench trials going into them, so we have to push to motion stuff to the docket, which inherently on the other end takes away other the criminals' rights, or not, like their option of a bench trial, right?
Yeah, because I don't see a world, like maybe some will accept it, but I don't see a world where certain people are like, no, fuck that, I'm not taking this docket, I want to deal with this right fucking now. They're already too fucking heated to have the foresight.
Another solution would be asking one of the MDT techs to just put a lock button on.
So here's my question.
I talked to him about it yesterday.
Here's my question. Say we lock it for the bench trial. For let's say yesterday's situation, we lock it, bench trial, he's found guilty. Now, when he gets the updated version of that report, because his report's gonna, he's gonna be sent a copy of the updated one, and he says, well, now there's evidence in here that would have helped me prove my case that he was innocent. Now we have another big issue, right?
Well, it should never. We should once it goes to trial, we should not be touching the at all. Like that's it. It's done.
So what I told Turner yesterday was, because this also bridges in. I was trying to explain to Turner. This also bridges in the FOIA issue, which we are actually really bad with.
It sounds like they messed up. Yeah, I mean, I'm not denying it.
I didn't even think about it.
They did mess up.
That once something's FOIA'd, like nobody can edit that report ever from that point forward.
Yeah,
because I didn't know that the PDF updates when like what the PDF you give the lawyer, it'll update with new updates. I didn't know that was a thing. So realistically, what we should be doing, speaking only on FOIAs, is when something's FOIA'd and it's fulfilled, that report has to get locked, and then somebody should copy the entire body into a new report, reference the FOIA report, and then all edits go to that new report.
Barrick doesn't know what he's doing,
and
respectfully.
that's how that's built on.
I don't disagree.
I know historically we have the FOIA
Well, here's the
process
thing.
tag,
I think
and what's
Yeah,
that
but that
tag?
doesn't. I haven't even fucking.
I don't think anybody's
I wouldn't be surprised if
100%
how PD
expert
doesn't
on
know that.
anything on the
I'm gonna be
server.
honest.
Unless
that was
it's
one thing
eating
never
pizza
taught to
and then
me.
it's
I never
forehead.
realized. I never thought of it. Nobody ever said it to me.
But you know what I mean?
never
To
realized that
have
process
like,
is-
dude,
it's in the
it's fucking
SOPs, my mistake,
crazy. The knowledge,
nobody
dude.
else
I had to
knows.
read fucking books and
so
watch
going
shit
back
to
here,
be a cop,
all
like
reports should
to
be done before it goes to
understand and
bench trial.
articulate
I mean,
and do this other shit.
Per SOP,
Medi had to put me on audit
everyone
the
has to get
audit.
that in.
Fucking, it's
Right, but-
crazy. Just to fucking play
if
make
somebody
believe in a
wants to
video
get a
game.
bench
The
trial, we have to
counterpoint
get
is
35 reports in.
it can be good money.
You know, on a scene like that, no,
Well,
we push it off to.
I think big scenes like
an
that is
appeal.
where we'd say this is a large scale scene.
Maybe we don't create. We just call it large scale, and we're talking, 6 to 10 plus. It's recommended to push off. I mean, yeah.
I just think with these sort of
situations
scenes,
span blocks at times.
the thing
Several
with
blocks.
these scenes
And,
for me for bench trials is I would be fine with going into a shootout for a bench trial, but if I'm in the bench trial and I say 20 cops got shot, and for me, if the judge's reaction is there isn't 20 statements in this report an hour after it happened, I just think that's fucking crazy. I think
that I don't disagree.
It does take. It takes 5 minutes to write your statement. It really does.
No, I mean, not even that, Mike. I think if somebody's requesting a bench trial, they're sacrificing
Time.
like they're getting the convenience of it happening now, and they're sacrificing like I'd say like the level of proving that it's a bad way to put it. Like
there's some exceptions made in bench trials
because
as opposed
some
to
of
full
like
trials.
yesterday the argument was being made that and I understand defense. I'm not putting against the defense at all, but they were stating the fact that the vehicle wasn't processed. Well, there's no evidence of the photo being there, the vehicle being there, but we have officer testimonies of the vehicle being there. And how is that in a bench trial format? How is that not enough?
Yeah,
in my mind?
officer test. You're not wrong. You're not wrong.
Testimony does need to be there.
Yeah, it does, but like in my mind for a bench trial,
held.
how is that not enough? I understand
Yeah,
for
it
a docket
also-
posting
if
when you
it's-
have
if it-
days to prepare.
It's
I
also it's
understand.
up to prosecution to point out the fact that through while the picture's not there are 3, 4, 5, 6 officer testimonies to corroborate everybody's story. It's not just one person saying it.
But you can't have that many witnesses either. They made an exception for 3 yesterday. Normally it's just 2 on bench trials. How did that go 5 hours with 3 witnesses?
It was a clown court. There was fucking unnecessary objections on both sides. It turned into a fucking petty off.
Okay,
So-
so I guess moving forward, we should probably get something written up reminding people that they can request that. I can have a chat with DOJ and just let them know we're probably going to be going that direction then.
That vein on your head
Falconer-
showing, Torner.
Falconer said he would, because I spoke to Falconer about this yesterday, and I expressed like the frustrations, and like I expressed also like whereas it's not really what's being said, the way this looks for PD is just like another fuck you kind of like fuck you didn't do your job, idiots.
It's another
like,
day with the DOJ. is
yeah,
what it
it's
is.
like it's just demoralizing. And like I tried to explain to Quangle. I said he said he didn't blame me for putting a report. I said I apologize for doing it, but it's like I don't know. I just feel like they could have exercised another avenue than just throwing out the whole case with prejudice.
Yeah.
It made no sense to me.
It felt like maybe something else was going on in their head, but it just felt like they were over it. They were probably like, it's a bench trial.
I don't think the case should have gotten thrown out. I think it should have been taken into account, but generally when something goes to trial, we should not be touching reports.
100%. 100% agree. That's why I was trying to explain.
I heavily disagree.
With what?
I heavily disagree here. It's not realistic to put a bench trial on for something like that. I guess we're
Peter's
talking
just
kind
saying
of
in
between
general.
here.
Peter's just saying in general that for cases when something's in trial, the report can't be edited.
That's it. But
I mean, it makes sense for the DOJ side, but any time that we don't have all the facts and statements in there, we can't.
It's because when the defense looks at the report at the beginning of the case, they have what's in front
I
of
got
them.
a picture of the unicorn. Well, that's what, dude. A lot of these trials are testimony.
I know that.
That's
why I'm
literally
saying we can't.
That's
edit them
literally
after.
testimony.
We can't
Like
add statements after. We can't add.
I don't know how it
evidence
works. How does it work after a bench trial, Peters?
Does
it have
you
to be a
absolutely
separate
can't.
report?
no.
Because
So
what happens when you have to
I
provide all the
think
information?
I
at the time
think
of the bench trial.
once a bench trial is concluded, whether it's a guilty or not guilty verdict, the report's done.
Yeah, it doesn't matter
served
anymore.
its purpose.
That's it. Yep.
I don't think a lock button will add.
Let me ask you this: you got 6 people arrested. One person contests, and the other one takes it to an appeal. Now that level of evidence is required, and those people who didn't put in reports,
So
because they have 48 hours,
what
and
it would be
evidence isn't in
basically,
there. Now
what would it
what?
be basically is like if I started a report and I went to bench, I'd lock my report and I would create a separate report, copy paste whatever body was in there into the new report, and then anyone else, I would put like a note saying, you know, reference this report, and anyone else adding new stuff would put it in that new report. And anytime any further FOIA from that point would FOIA the new report.
Again, that creates a slippery
So-
slope when you're
so-
not providing all
that's
the
getting
information.
messy.
No, but how else do we go about it? That's
okay,
how
so
that's how it
real
should.
quick, the purpose of a FOIA, it's basically to see the documents of something that's already done. The whole thing is if somebody FOIAs something, we should be concluded and there should be nothing being added to it, because one of the stipulations in the FOIA legislation is like we could deny it if we're working on an active report. It's basically for the public to check to see like the findings that we had. So we shouldn't, once somebody FOIAs something, that report should never be touched again.
I agree.
And
FOIA is also afford us 72 hours to make sure everything's in order.
And also,
Whereas bench trials
if you're
are
going
different,
through the proper, like let's say, you know, it's FOIAs and goes to docket at this point, you can always, as the prosecutor, motion to add evidence and justify the
it
addition
is
of
on
the
the
evidence.
cops. It is on the cops. That's what I've been saying.
We need to update the PD's general understanding to FOIAs then, because what was the shift 3 thing that happened where somebody fulfilled the FOIA within 48 hours?
Oh God, that was
and
the
didn't
moose,
like
the moose knuckle thing with Chop.
no, it was something recently. I think Tony Lung FOIA'd a report for Hydra 36 hours after it happened, and it got fulfilled because like the reporting officer gets the FOIA request, right? And the reporting officer didn't speak to the processing officers to make sure that they were done. He just checked and saw, okay, statements are here, evidence are here, looks good to go, and did it, right? Whereas we were still within our SOP window to update the report, and there was still stuff missing that was needed for that. And I think some people just might not have the understanding that they have to contact every processing officer and make sure every processing officer is 100% done with what, even if like Arnie is getting FOIA'd,
24091.
Benz was arrested in the same report, Benz's processing officer has to be contacted too and say, hey, Benz isn't FOIAing this, but it's getting FOIA'd, so it has to get done.
Okay, I kind of want to narrow this in a little bit.
ADHD
so,
going off the wall?
Pardon?
So you're meeting ADHD going off the wall?
No, I just want to narrow in back on the focus, as in looking at the original problem. What do we feel like is the best solution to this? Is it just announcing, being like, hey, when it comes to something of this scale and a bench trial is requested, you spend every second and every moment taking your time to make sure every statement is in, every drop of evidence, everything, because while they're requesting the bench trial, they don't have any kind of right to wasted time. Is this about our officers making sure that everybody gets every drop of evidence in, then boom, report's locked, bench trial happens, that's that? Or do we set a standard of, let's say, 10 plus OIS is
I still think 10. I still think 10's high.
Yeah, give a call back here in just a moment, Reddick.
Like,
okay, so if
unless,
you
if
come over,
DJ's
that's
gonna
fine.
take statements, and, like,
one sec,
accept that,
Ventor, if you feel like do you guys feel like 10 is too high? Peters, Werner?
I think it's more situational. We can have a shootout with the 6 people that span several blocks, and 20 officers are shot. So okay, you're talking about, I'm sorry, 10 officers. I think it's situational. I mean, let me ask you this. How many times have you been involved in a shootout where somebody got treated because the situation moved and they were off duty by the time you finished? Happens all the time, right?
by the time everyone gets medical, everyone gets their cars back, everyone gets the PD.
Okay.
Yeah, like 4 people go off duty.
It is.
So I guess there's situations. I'm not saying.
So what you're
it's like
saying
a
is
flat-
instead of setting the standard, we just reinforce the officers,
right.
just being like, okay, you guys need to make sure every drop is in when a bench trial is requested. Take as much time as you need. I know it's going to suck, and that whoever that person is probably going to be yapping their fucking tits off because they're upset they have to wait in the cells. I'm sorry, but like you're requesting this bench trial, we have to make sure our T's and I's and J's or whatever are dotted. It's your time. You're requesting this. You don't have a right to time.
Yeah, if they're requesting it, we got to make sure it's all done. And if we can't facilitate that, like somebody's not available and they're key to it, then we have to state that we don't have we're not able to fulfill a bench trial request right now when we request one, and we request that it goes to an appeal.
What were you gonna say, Peters?
No, it's like I had a situation with Pred this week. Pred was arrested. He had a shotgun on him that came back to a shootout that I'm 99% sure he wasn't involved in. I tried to get him into the interrogation room. He ended up holding up an officer, escaped. He actually did this whole thing fucking twice. After he was back down here, he asked for a bench trial. I then said, this is going to be way too much for a fucking bench trial. Just cut him loose and put it on the docket. We can do that. And I think Turner's onto something by saying it's situational. If somebody asks for something, we do have the means to, and to kind of like reinforce what McNulty said as well. We could hold somebody as long as we need to conduct an investigation. If they ask for a bench trial and we are within our means to give it to them, if they need to sit in a cell for a fucking hour, so be it. I mean, it sucks.
Yep.
But that's it. If it's completely impossible, then I think we need to put it on the docket. The thing is, if we're putting it on the docket, we then have to cut them loose. And if I'm a criminal though,
wait. If it's going to it's an appeal. You charge them for
Peter's
it.
just talking about if you're still looking into facts to try to figure out what's being charged.
We can't. The thing is, if they ask for a bench trial, we can't just say no and send them up.
I think
we would have to.
If the judge refuses the bench trial because one side's ready, they do. It does get pushed to appeal. I think cutting loose and being us pushing the docket is when we've still not collected all the evidence. We don't have all the stuff to prove. We don't have everything's not figured out on our end.
So I think it's one thing if you feel like, okay, we had grounds to detain them, we have grounds to arrest them, but we still have pending charges that we're going to look into, because I feel like I can't push, let's say, first degree right now. I can only push assault with a deadly, but or let's say we're pushing
no, you can't just
degree.
charge them for it.
Or we want to push attempted
if
first
somebody
degree.
asks for a fucking, if somebody asks for a bench trial,
they might die.
Okay. Here's the thing.
If you need to gather further evidence to further your charges, that's one.
I don't think you should be fucking charging someone for, like, especially if you need to prove it in a court of law.
That would be an appeal, I think.
I think you have to look at it from a role play scenario.
Hold or cutting someone loose.
Because I think you're just ultimately fucking someone's role play by doing that.
I mean, that's what I think. I think if I know we had a fucking.
If there's a judge, that's a different story.
12 cops or 32 cops, whatever. I knew that was a thing. We have 32 names. We have 32 301s. We have people are out there collecting evidence. People, whatever. We have all the guns, and I'm ready to charge somebody with 32 times and possessions. I shouldn't have to cut them loose and have to post the docket. I know what they're going to be charged with. It's just not all in the report yet to go to bench, and that's when they would appeal at a later date, and they would have access to all the evidence. But if our communications went down and we knew cops got shot, but we didn't know how many because we're communicating by carrier pigeon, and we didn't know how much to charge them with, then we might cut them loose because we don't have that finite number yet of what we're charging them, and we're not going to hold them.
I like how Ventura uses
times while we're trying to.
I like how Ventura uses these words.
That's when we would push that to the docket.
Like, what did he say to me the other day?
Okay. It sounds
just to
like
reel it back in. Just to
guilty and proven innocent. That comes into a court of law. That's not what the cops always think you're guilty. Just that's life.
So when we walk away from this, are we just going to say we need to reinforce the quality that needs to be approached on a bench trial, and reinforcing the fact that the 95 in the cells isn't about to bully an officer into saying, like, hurry the fuck up, I've been down here for an hour. And I'm like, yeah, you have been down here for an hour, and you're going to be waiting here a lot longer while we get, the 30 plus statements in, because instead of going to the docket where, you'd be free and roaming, this is what has to happen now.
I think we need to talk to the justices and figure out what the standard is that they look for a bench trial. I'm of the mindset that a bench trial should not be beyond a reasonable doubt. It should be based off a preponderance of evidence, which is basically 51% guilty. If they want beyond a reasonable doubt and they want the same format as a docket posting, they appeal and they take it to docket. If they want the speediness of a bench trial and here, now, and there, then we shouldn't have a fucking microscope.
Yeah, then they need to sacrifice their patience as well from the 95's POV.
An example of that is like what I said is like
cops too is
if 20 cops got shot down and we have 20 cop names in there and we have statements that a shootout happened, a judge should not look at that in a bench trial and be like, well, there's only 12 of you that wrote in here in this hour window since you all got fucking gunned down, so I'm only charging 12. That makes no sense. The judge should look at that and say, okay, the officers saying 20 cops got shot. I have 20 officers' names laid out here. I have a bunch of blood. It's looking like that is what happened.
Okay, while I agree with you, it is also up to the prosecution to highlight that.
Sure, I mean that's just the prosecution's job and
Yeah.
the bench trial to do that. But like I said, I think that it all starts with a talk with the justices to figure out what the standard they are looking for in bench trials, and then based off what they say, then we can look about how we act to that, right?
Okay, there we go. I like that. Sounds good.
Is that what you were talking about, Turner? Because like then we figure out if they have a microscope on us, then we maybe be more selective with how we go about them, right? Because we know that the bar is that high.
Well, there's definitely talk to them. It's more so what we think is right, and then I'll plan on taking it to them and seeing.
I think that's the best way
is.
to go about it. If I'm honest.
Am I like the minority in the mindset that a bench trial should be a little more lax in terms of like?
I don't think you're wrong.
Articulation has to be there, but in terms of like I don't know.
I think Ventura, that's been the mindset always. But
it hasn't been
while it's lax, that doesn't mean we shouldn't take it seriously. It is a mass shooting. Sure. And the level of the quality should still be there, but like I feel like the quality shouldn't be scrutinized as much when we have to wrap that shit up in less than a couple of hours. Yeah, I get you.
That's my point. You have by the time between the bench trial request and like you've literally probably had 15 minutes of by the time you got there from CMC to them screaming for a bench trial. Like you have no time to do your shit.
So walking away from this, reinforce it to officers and also ask DOJ in terms of quality what they're looking for in bench trials. Should we be treating
I think we
that
go
like
DOJ first before we reinforce it
okay.
make sure that
sounds good.
We're in line.
What are you laughing at?
He's like a caged animal.
No, it's less that. It's more
I know
just trying to hone in and get a solution.
This is funny.
Okay. All right.
Peters Radich?
I mean, I've always been under the impression that bench trials are, like you said, a little bit more lax maybe in procedure or what you bring to the table, right? Less prep, so they kind of account for that and give some leeway as far as the DOJ goes. But I also agree with the opinion that we can't take them less seriously. You know what I mean? Especially with the tone of most bench trials recently, I think that it's important that if we're not going to be passing the bar on things, that we shouldn't be forced into a situation where we're at the disadvantage because we didn't have time to prepare and they want a bench trial,
Okay. So Tony, you're gonna bring that up and we'll reconvene and try to get something settled.
Peters, do you have anything else you want to?
No, I mean I'm very firm on the mindset, kind of like if it's going to bench and we need. I mean the whole thing I said. If it's going to bench, it's on the officers that are going to court to make sure everybody has their statements in.
Yep.
And the thing is ready to go. We shouldn't like this is it's a fuck up on the PD, but I don't want to say again. I think throwing it out because Ventura edited his statement is kind of fucking extreme for the DOJ.
Was it edited or added? You added.
I just threw in. I had like half of it written. I just added the part that I got shot down and got medical.
Yeah, so it's like I mean it is what it is, but it's kind of like moving forward. I think the solution is a bench trial, and somebody wants a bench trial. Officers need to make sure 100% the report's done. That's on them. If they don't have statements or whatever, and they go to trial, that's it. Yeah, but it's on them to make sure everything gets done.
I just want to avoid us like needlessly denying bench trials. I like bench trials.
Yep.
I hope we can keep doing them. I think people have the right to them. So.
All right.
Good shit.
Sounds good. I'll talk to some justices and I'll relay back what happens.
Make sure to
Does
take
anybody
a
specific want to come with me?
Take a headache tablet or something, Torna.
I mean, I'll go with you, Chief.
I'll come to. Do you want me to go as the BCSO rep, or would you like to go to a meeting with the justices, McNulty?
Is that a rhetorical question?
I just want to offer the door, offer it to anyone. I know I want to go. So
I can go.
Ventura, please. Thank you.
I gotta bounce out for a little bit. I'll be back a little bit later.
All right.
I'll make a Subway Surfers TikTok video for you.
Not again.
With the
Not
breakdown,
again.
McNulty.
Oh, yeah, actually, please. I'd love that.